Welcome to Based in Fact, a true crime podcast. We're your hosts, Lisa O'Brien and Kyle Evans. And Rick Mullinax of the Burn After Reading podcast has agreed to join us today for episode 10, State of Ohio versus Mackenzie F. Shirilla. And this is a case that basically has happened in Rick's backyard, if I'm not mistaken.
Yeah, it took place about 9.2 miles away from me.
Okay. On July 31st, 2022, the volatile 4-year relationship between Mackenzie Shirilla and her boyfriend Dominic Russo ended when Shirilla drove her 2018 Toyota Camry at 100 miles per hour into a building in Strongsville, Ohio. Dominic was killed on impact, and their friend Davion Flanagan died at the scene. Shirilla and her parents claim the incident was a tragic accident caused by a medical condition. Shirilla's tumultuous relationship with Dominic, their text exchanges, along with her post accident social media posts, led many to question that explanation. After a thorough investigation that ruled out a medical cause and mechanical issues with the vehicle, Shirilla was arrested and eventually tried on multiple criminal counts, including the murders of Dominic and Davion. We'll look at the investigation, Shirilla's arrest, and the transfer of the case from juvenile court. Then we'll look at her trial and direct appeal and her unsuccessful post-conviction claims and why the Ohio courts have declined to hear them. So, good afternoon. Happy Sunday.
Good afternoon. Happy Sunday.
Happy Sunday.
How is New
And
Orleans treating you?
New Orleans, it's a shit show as always. And
Tell us how
and
you really feel.
in 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 a spirit of full disclosure, I'm actually on the side of the AG. I don't think anything that the city of New Orleans leadership has done in the past 20 years has been legal or right.
That
And
is not surprising.
so, um, but no, I'm glad that they got smacked down when they tried to do something shady, and then they tried to do something even shadier by indicting a sitting attorney general of the state, and that blew up in their faces. And I say, yay, good. So, um, but enough about me. So, this case, there is a lot out there. And so I am going to start this off right now by saying I'm trying to focus as much as I can on the legal aspects, but we will talk at the end about some of the podcasts and some of the things that are out there. And trust me, I will have recommendations for some ones that I have found very interesting and very helpful in understanding the minutia of this case, because this is a case with a lot of minutia. And part of it is because it's a teenager who posted her entire life on social media because she wanted to be an influencer. But folks, she was a bad influence. Do not do anything she does. All right.
Yeah, don't they all want to be influencers now?
Yeah, and it's really scary. All right, so the victims in the case are Dominic Anthony Russo. He was born September 24th, 2001 in Ohio. His parents are Frank Russo and Christine Agnella Russo. He has 6 siblings: Angelo, Christopher, Christine, Nicole, Michael, and Frank. I believe that is their birth order, but I could be wrong. He was a graduate of Strongsville High School. He graduated in 2020, so he's one of those kids that had his senior year essentially killed by COVID.
Yeah.
Um, he had interest in business, music, cars, and he was also thinking of joining the military, from what some of his family members and friends have said. Um, he died of multiple blunt force injuries secondary to a motor vehicle accident, and the primary injuries were to his head. Then we have Davion Markel Flanagan. He was born March 11th, 2003, also in Ohio. His parents are Scott Flanagan and Jamie Doyle Flanagan, who adopted Davion and his 2 sisters when they were younger children. He has a sister, Divine Isabella, and another sister, Dahlia Rose. He was a graduate of Strongsville High School. He graduated in 2022, and his interests were athletics, football. He was a running back on the high school team and a starter in his senior year, and he wanted to be a barber. He also died of multiple blunt force injuries secondary to a motor vehicle accident, and his primary injuries were to his trunk and abdomen. The perpetrator is Mackenzie Ford Shirilla. She was born August 2nd, 2004. So keep this in mind. On the day that she killed Dominic and Davion, she was 2 days from her 18th birthday.
Oh wow.
She was also born in Ohio. They may or may not have all been born in Strongsville. I couldn't find any information or in the Cleveland area. Let's just say that. Her parents are Stephen John Shirilla and Natalie Shannon Shirilla. She has a younger sister named Danielle, who is, I think, a foundling who was not born of the Shirilla genes. And I mean that was no disrespect to Danielle, but she's the polar opposite of her sister. From every little bit I can garner from about her.
So she's not
Uh,
psychotic.
no, she's in college somewhere, I think, in North Carolina now. So, um, she graduated from Strongsville High School in 2022 and also attended the Polaris Career Center
which I did too. So that was
during high
something new I
school
learned.
and almost got thrown out of that Polaris Career Center, which from some of the comments I saw, it really takes, a lot for them to throw somebody out.
Hmm.
And that she almost got thrown out is shows that she's a special kind of stupid. Um, Emotional mental state, she's a narcissist, she's abusive, she's a racist, she's a drug user, and I suspect that she has anorexia and or bulimia because of how thin she was and her exacting control over a diet that's referenced in some of the statements made by Dominic's family.
Yeah, she's
Um,
terrifyingly skinny.
yeah. Her prior crimes include fighting, menacing, bullying, theft and shoplifting, breaking and entering, road rage and menacing, assault, drug dealing, and prostitution. And her victims were Dominic Anthony Russo, who was 20, and Davion Markel Flanagan, who was 19. Um, Again, this occurred on July 31st, 2022. The victims were Dominic Russo, 20, and Davion Flanagan, 19. The crime occurred at 11792 Alameda Drive, Strongsville, Ohio, and that's in Cuyahoga County. Am I pronouncing that correctly?
Cuyahoga County, yes.
Okay. Cuyahoga or Cuyahoga?
Cuyahoga. But
Cuyahoga.
it's also depends on just how you speak. you know, like Louisville, like you always hear
Yeah.
things. So, but
Louisville.
Cuyahoga,
Yeah.
yeah.
Okay. Um, Shirilla and Dominic started dating around 2018 when she was a freshman in high school. Shirilla was 14 and Dom, who was slightly more than 2 years older, was about 16. According to some accounts, Shirilla pursued Dominic, who was a junior at the time. Based on text messages and accounts from Dominic's family, the trouble in the relationship started around 2019. Texts between Shirilla and her father demonstrate that her parents consistently failed to set even minimal boundaries for her. They allowed their minor daughter to sleep over at Dominic's house or allowed Dominic to sleep over at their house. They also knew about Shirilla's drug use, yet gave her a car to drive. And I mean, she posted videos of herself doing drugs, and her mother liked those videos.
Yep.
So,
Yeah,
we're talking
not turns of
twisted.
the year.
They also made excuses for Shirilla whenever she got in trouble. They'd let her play the victim when she was accused of menacing, bullying another student, and when she stole from Kohl's. They wanted to be friends with Shirilla and seemed to have no desire and or no ability to exert any authority or control over her. In fact, it appears that it was Shirilla who controlled her parents. Even when they tried to set boundaries, she was rude, obnoxious, and disrespectful to them. Yet she doesn't appear to have ever suffered any consequences for the disrespect. Shirilla also dominated and controlled Dominic. If he went out with his brother Angelo, she raged at him. She threatened to hurt Dominic and herself when he didn't or wouldn't give in to her demands. She menaced and bullied him the way she'd menaced and bullied other girls in her classes. By early 2022, the relationship had become even more volatile. In the last year, the pair had an off and on relationship, repeatedly breaking up and getting back together. When he suggested that they end the relationship for good, Shirilla became enraged and threatened Dominic and his belongings. Shirilla had other relationships but refused to let Dominic go. On May 29, 2022, Shirilla and Davion graduated from high school, and it was at this time that the relationship between Shirilla and Dominic became more strained and volatile. On July 17, 2022, during an argument with Shirilla while they were driving on I-71, Dominic called his mother for help. His mother was in recovery from surgery and turned to a family friend, Christopher Martin, who agreed to help and called Dominic. During that call, Martin heard Shirilla say, "I'm going to wreck this car right now." When Martin found Dominic and Shirilla parked on the side of the road on I-71, they were outside the car and Shirilla was upset and yelling at Dominic. Martin then saw Shirilla hit Dominic. Later, Shirilla sent a text to Dominic's mother claiming that it was Dominic who was trying to crash the car. Shirilla also made this claim in subsequent texts to Dominic. As most abusers do, Shirilla put all the blame on Dominic. She also gaslighted him, projecting her own bad behavior on him and playing the victim. Whatever occurred on July 17, 2022, Dominic got past it and his relationship with Shirilla continued. On July 19, 2022, Shirilla and Dominic broke into the Columbia Church of God, an abandoned church in Columbia Station, Ohio. Shirilla videotaped the crime and posted the video on Snapchat. Still images show Shirilla posing in a mirror inside the building and snapping a selfie. She also proudly posted videos of herself using drugs and driving recklessly, including at least 2 road rage incidents. On July 21st, 2022, Dominic recorded Shirilla raging outside his house after yet another argument had gotten out of hand. Shirilla threatened to key Dominic's car and destroy the door to get into the house. During the recording, Dominic said that Shirilla had broken up with him that day. According to Dominic's family, he had finally had enough and was ready to end the relationship for good. And I want to interject here. While the family has said he was thinking about joining the military, I think that thought was joining the military to get away from Shirilla.
I don't blame him.
I'm just going to put that out there. She doesn't want to believe it. Her mother doesn't want to believe it. But a case that we'll probably look at pretty soon. I didn't think of it today. I wish I had. She would probably follow Dominic if he did join the military. So it probably would not have been successful.
No, yeah.
On July 30th, 2022, Dominic, Davion, and Shirilla attended 2 graduation parties. They arrived in Shirilla's 2018 Toyota Camry at the first party at around 10:15 p.m. and left after a few minutes. Their next stop was another friend's home for a, quote, sleepover. Shirilla brought mushrooms to that party so that partygoers could trip, but that didn't happen. Shirilla was observed sleeping alone on a couch at around 4 a.m. After 5 a.m., the trio left that party. Shirilla was driving with Dominic in the front passenger seat and Davion riding in the back seat. At 5:34 a.m., Shirilla made a controlled right turn from southbound Pearl Road, Ohio 42, onto Progress Drive, heading westbound. The vehicle then rapidly accelerated, swerving to the right and going off the roadway before it blew through a T intersection. The vehicle then jumped the curb, crashed into a sign in front of Plidco, a business at 11792 Alameda Drive, and struck the brick wall of that building. The force of the crash threw Davion into the front seat on top of Dominic. Shirilla was thrown from the driver's seat onto the floor across the driver and passenger sides and pinned in by the passenger side of the dashboard. And she was wearing her seatbelt. That's the force of the collision. And I've seen some people say, oh, well, that proves that she had some kind of medical episode. However, we had a case at one of my other firms where the woman hit a stationary service truck on the highway on the interstate, and she was wearing her seatbelt, and she was thrown exactly as Shirilla was across the floor of the front driver and passenger seats.
It's still
So,
amazing she survived. I don't know if you've seen the video of the crash, but it's
yes,
shocking that anyone could have
it
survived that.
it is. But I think that her having worn her seatbelt attributes, plus most of the damage was on the passenger side of the car, not
Right,
the driver's side.
right.
But the force of the very sudden stop at such a high rate of speed is what threw her out of the seatbelt onto the floor.
And
Um,
I know certain things are going to be brought up later, so I don't want to get ahead of it. But just based on what we know now, based on the timeline that you're reading, is she has anger rage issues.
oh yeah.
We've known that she has rage issues, that she has threatened to crash the vehicle before. We have all these things, and I don't know too many cases where there's a controlled turn to the right, and then all of a sudden this crazy acceleration, and that's either due to whatever medical issue, and there's been a few of them that they threw out there.
Mhm.
It's highly unlikely.
Yeah. And Progress
Yeah, I
Drive,
think that's
from
an
what I understand,
understatement.
Progress Drive, sorry, Kyle, from what I understand, is a twisty, turny, curvy
Yes.
road.
As you drive, it goes straight, but then it starts to curve to the left, and then it kind of it straightens out again. And
Hmm.
so, if she had a medical episode, just based on this stretch of road on Progress,
Uh huh.
I would have assumed that she would have hit one of the other buildings first.
Right.
So before it hit that you
Right.
know the T intersection, which I think was more to the right hand side. But it just, yeah, it that didn't jive with me because I've driven the road out of curiosity. You could look at it in a map. It's just this medical issue based on all other evidence and other evidence that you'll get into. It just, like I said, it doesn't jive.
Hmm. Yeah. I totally agree. And when you look at it, she actually, I described it, but she actually, right before the T intersection, she swerved to the right. And I
Hmm.
think that may have been some attempted intervention by Dominic
Yeah.
to try to stop the car. Thinking of their last moments just
Yeah, because if I
breaks my
recall,
heart.
right, there's no evidence she ever braked, correct? And
No, there is a video and you see the brake lights illuminate, but that's after she's left the roadway, and it's probably safety features from the car, which we'll get into a more detailed explanation of that later. But no,
Yeah, because
she never
there's, yeah.
braked. It was 100% throttle the entire time.
And there's some evidence to suggest a potential struggle, which again, I don't want to get ahead of it, but I think that's
Hmm.
important to note.
Yeah, because the car was shifted into neutral and then shifted back into drive.
Right. And I didn't want to say that in case
Yeah. No, no,
until
no.
you got into it.
No, because that's something that, like, was in my mind but didn't make it into my notes. But I'm glad we discussed it
Hmm.
now.
Okay.
At around 6:15 a.m., a passing motorist saw the crashed vehicle and contacted 911. So about 45 minutes after the crash. When officers responded to the scene, they initially believed all three occupants were dead. The engine wasn't hot, and it was obvious that the crash occurred sometime before they'd arrived. The Strongsville Fire Department and Berea Fire Department and paramedics responded to the scene to assist. Shirilla was extricated from the car and life flighted to Metro Health Medical Center in Cleveland. Davion was removed from the car and briefly treated at the scene, but passed away in the ambulance. And there's kind of conflicting information about that because I watched a couple of the other shows, and they said that both Dominic and Davion died on impact, but it appears Davion did not die on impact, but he was gravely injured.
Yeah, and the body cam, the law enforcement thought that they were both dead at that
Hmm.
point, so that may be where the confusion came from, just
Yeah,
visibly.
yeah. But I did find in the documents, I did find a report that shows that paramedics treated
Hmm.
Davion at the scene. Um, Dominic unfortunately was declared dead and remained in the car pending the arrival of the coroner. During the investigation, Strongsville investigators collected available video footage from the buildings around the crash site. The investigation included an in depth forensics examination of the vehicle, which ruled out any mechanical failure of the steering or braking systems. GPS data from Shirilla's phone placed her near the crash location at Progress Drive in Alameda on July 28, 2022. Uh, Shirilla's controlling and abusive behavior toward Dominic continued even after his death. Because she couldn't attend the funeral, she sent a friend to FaceTime her during the service, and that video was posted on Instagram. Shirilla also continued to post videos on social media, and she and her mother responded to a modeling opportunity while Shirilla was still in the hospital.
Oh my
Shirilla
God.
and in that post, her mother is like, "But it was a horrible accident, her love of her life, blah blah blah." They're just so tone deaf, it's not even funny.
The idea, like she was so excited, Mackenzie, when that modeling
Uh-huh.
agency on I don't know if it was Instagram or TikTok, but one of those two, and those messages, she was so excited. Now you just lost the alleged love of your life.
Yeah.
You would think that would be the last thing you would want to think about,
Yeah.
because you lost
Yeah,
someone who's irreplaceable, and
you
yet
wouldn't be
someone,
excited
yeah,
about anything.
Yeah.
right. That's what I mean. That's at least how normal people would behave.
Exactly.
But Shirilla and her parents, they not normal.
No, not at all. Not at all.
Shirilla also exchanged repeated texts with Dominic's mother in an effort to gain entry to Dominic's house and attempting to get the Russo family to support her in the community. Sharilla's parents were no better. Sharilla's mother, Natalie, told Dominic's family that Sharilla's condition was critical and she was still unconscious. That was untrue, as Shirilla had been conscious and alert since shortly after she was extricated from the vehicle, and she was posting videos on social media while still in the hospital. Her condition was critical because she did have some internal injuries,
Well, I
but
think
she
that
wasn't
just the
unconscious for
I
days.
think the I think the posting of the funeral and just all the Instagram stuff to me just screams like she is clearly psychotic. I mean,
Hmm. Yeah.
posting a funeral on
Well,
Instagram of
this
somebody you just killed, even if it was an accident, is just psychotic.
exactly. My thing has always been, I believe from the very time I watched The Crash on Netflix that if she couldn't have Dominic, nobody was going to have him.
Yeah.
Exactly. Like there's a lot of correlation in a lot of cases, but when I saw the crash, and of course, understanding the news reports as these things were happening, it reminded me so much of OJ and Nicole. Just
Yeah.
that control, the abusiveness, and if finally someone has a breaking point, and when they're breaking free, yeah, then it comes to that. Well, no one's going to have you, and it's
Hmm.
uncontrollable rage and anger. The way it happened, of course, was different. Car crash versus, a butchering, but very, like
Yeah.
I said, very similar.
Yeah.
All right.
So, all right. So now we're into some of the events. I'm just going to kind of touch on them. On May 19th, 2022, the Shirillas filed a voluntary petition for bankruptcy in the Northern District of Ohio, seeking protection from creditors under Chapter 7 of the Bankruptcy Code. Shirilla and Davion graduated from high school on May 29th. The incident on I-71 happened on 7/17. July 17th, the recorded incident at Dominic's house happened on July 21st. Then Shirilla appears to have made a scouting trip in that location on July 28th. Uh, and even though they claim, oh, there's some kind of organic food stand in the area that they went to all the time, the only time her phone GPS places her there is that one day.
Mhm.
So if you went there all the time, then why isn't there more GPS data on your phone putting you there?
Right. And why did she go there?
She says there's an organic food stand,
Oh, you mean she was
organic
scouting for the
vegetable and fruit
crash?
stand. We think she was, yeah. The
Ah,
police think she
got
was
it.
scouting the crash site because it's
Ah,
not.
got it.
Her family's like, oh, what was a cut through? It's not a cut through from where they live.
Yeah, and it's an industrial, an
It's an
industrial
industrial
place. Yeah,
street.
right.
I mean,
Yeah, it's not a doesn't look like a place you would drive through accidentally.
no. And I mean, Rick, can you get to their houses from that area? Is it a shorter trip or is it a longer trip?
That's a good question. That I don't know.
Okay.
I don't know her address, but that's something I would like to look at. But regardless, even familiarity with a place,
Yeah.
I mean, I'd like to know a little bit more about the travel and why that area would be somewhere she would travel,
I
why she's driving with Davion and Dom. But
I know Dominic was on Lunn Road,
mhm.
Lunn Road near a school. You know what? I will email you their exact addresses because I have it in the documents. I don't have it here.
You say Lun, Lunn?
Yeah.
Okay, yeah. Let me take a look at that.
And then I can't remember where her parents' house was, but she wasn't really living with her parents at that time anyway.
Hmm.
I mean, that's the thing that gets me. She's 15, 16 years old, and they're letting Dominic sleep over, and then they're letting her move in with him. It's like, no, I would have never left the house if I proposed such an idea to my mother. I would have been still living in the house when I was 30.
Yeah, I mean, you can tell there's something seriously wrong with these people.
So,
That's
um,
a very
and
early sign of it.
I, I've wondered if Shirilla was, of course, she was the first child, so that could be part of it, but was she sickly or chronically ill as a young child? Like respiratory issues or ear infections or asthma or something like that, where she had a lot of doctor's treatment, a lot of visits, was sick a lot, and so her parents couldn't tell her no. And then when she recovers from those childhood illnesses, then they can't tell her no because she makes such a stink when they do. And so
Right.
then they're afraid to tell her no.
So I am looking at it, and if we're looking at Lund Road and where they would travel,
Uh huh.
it would actually be logical to go that way.
Okay.
Progress Drive to, and it just turned. I'm just looking at the mapping now.
Hmm.
What is it called?
Alameda.
Alameda, yeah. And then they would go. They would turn right onto Westwood, and then left onto Prospect Road. They would go all the way down until they finally hit Lunn.
Okay.
So it would. I mean, honestly, there is some logical things, but that aside, that still doesn't mean anything.
Yeah. Yeah. It could be but no, there's no need to cut through there on at 5 o'clock in the morning. I
Well,
could see trying to avoid traffic because that was what somebody said was, oh, it was to avoid traffic on Pearl Road.
if anything, if they wanted to avoid something, it wouldn't be traffic. It would be if police were out, and
Oh.
if since they had a bag of, even though she wasn't under the influence of psychedelics, she had
Uh-huh.
THC in her system, but she had that all the time.
Yeah.
Um, so they could have like went just straight all the way on 42, which is Pearl Road, and then took I believe it would be they would hang a right onto Lunn. But I can see if they wanted to escape any kind of like police monitoring anything and
Mhm.
setting something up. I can see why they would go that way in the interest of fairness. I can see why.
Okay. All right. Well, that's all right. Her parents aren't that
But
at
here's
least turns out to be
but
true.
but here's what would make it interesting also. Let me also just say this. If she is not known to have done that, if they have like logs and even at different times of night they never did that
Uh-huh.
and she only did it that one time and she was claiming it was to go to like an organic food
Yeah.
stand or whatever, those type of things, because I would think the defense would show like, look, she always crossed there all the time, here's the
Yeah.
data.
And
So if there's no other data showing that she's ever done that, then the scouting thing has potential.
yeah. And
Well,
like
and
I said, as I said, her GPS data does not routinely show her, and you know that bitch did not go anywhere without her phone.
Right.
So,
I
you
was
know,
going to
the
say
GPS
too, I
data.
mean, like having teenage drivers, they really don't understand like alternative ways to go, right? They go the way the map tells them, and even if you tell them there's a faster way, they're like, no, 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 I have to follow the map. So
Uh-huh.
I'd be shocked if they're taking off some back road, like because they just, oh, they know it's a cut through and it's faster. I mean, we don't know, like, right? It's impossible to prove, but my guess is they probably usually just went on the main roads based on how I see all the people her age driving.
Yeah.
Yeah, and like I said, and at best, it was to avoid Strongsville police.
Okay.
If it's because since it is a main road, but that's at best. Otherwise, it would be more feasible to just continue to go, down 42 Pearl Road and then go on the Lund Road that way because it's right there versus the other way. It is an out of the way thing, but the only logic that I can come up with is that if you're just trying to avoid police and getting pulled over, but that still doesn't make a lot of sense because it's like 5, 6 in the morning. It's not 2 or 3
Mhm.
where
Yeah.
that might be more suspicious. But again, if it's data and it's showing that she doesn't go that way often, and it would be different if she said, "Well, no, I just went that way to go to Dom's house," that would make sense. But if it's just for this, organic food stand, mart, whatever it was, then that doesn't make
Mhm.
so much sense.
Yeah. Alrighty. So now we get into the investigation, and this is what jumped out at me. Not necessarily everything. I may have missed things. I certainly did not go into all the text between Mackenzie and Christine Russo um, because it was overwhelming
Hmm.
to see her gaslighting Dominic's mother, and it made me really angry. So I was like, okay, I'm not going to go there.
Let me say one thing really quick, and I'm
Hmm.
sorry. I just because I don't
No.
know if it's addressed. In the documentary, The Crash, we see the body cam of Dom's father when he was told the news
Hmm.
um, that his son, there was a crash and it was fatal. What we don't see is the body cam of Dom's mother, which was
Yeah.
which was before, and I don't know if that's addressed or not. But it's horrific. It is heart wrenching to watch.
Yeah.
And one of the things that she says towards the end of it is, "What has she done?"
Yeah.
Repeatedly.
Yeah. Yeah, but I think the mother was afterwards because I think the father was there.
No, he was sleeping.
Okay.
My understanding was that that happened first, and that's why, because at that point he knew what happened, but the police were formally telling him, and that's why he seemed a
Oh.
little more calm compared.
Okay.
Yeah,
Okay. Got it. All right. See? That's another thing. And again, I'll have some recommendations for places for deep dives into the the wealth of information that we have because of the social media age that we are in
right.
now. So, the forensic examination of Shirilla's vehicle occurred on August 5th, 2022. That was done by the Ohio State Patrol accident reconstruction expert at Center Towing. The initial finding was that the airbag control module indicated no braking for the vehicle and a request for 100% acceleration with full pedal pressure. Now, something that's been mentioned by Shirilla's family is that apparently the airbags did go off before the impact with the building. So a few seconds before the impact with the building. However, that may have been done when the vehicle left the roadway. That may have happened at the time of the crash with the sign.
Mm-hmm.
Or it may have been when it left the roadway in anticipation of a rollover, because that's what the module is designed to do, to protect the occupants of the vehicle from what's about to happen, rather than waiting for it to start before the airbags go off. So, but again, that's the findings from the airbag control module. Then Shirilla on August 6th sent a text to Angelo, Dominic's older brother. Hey, Angelo, I don't know if you hate me, but tomorrow for the funeral, would you be able to go into Dom's room and grab some photos from his desk for me and him so I could put them into the casket so he can be with me forever?
Ugh.
And that shows you exactly, I think right there, that this was not an accident. And saying, I don't know if you hate me.
Yeah. Like
Oh.
she's trying to test it, and then also just this disgusting thing of putting her photo in his
Mhm,
casket as the last piece of ownership.
mhm. Dominic's visitation was on August 7th, 2022, at A. Repepe and Sons Funeral Home in Middleburg Heights, Ohio. His funeral was August 8th, 2022, at St. Joseph Church at 11:30 a.m. Apparently, I believe it was the funeral where she sent somebody to FaceTime her, and then that person posted that video or sent it to Shirilla, who posted it on Instagram. He was interred at Strongsville Cemetery. Davion Flanagan's visitation was on August 14th, 2022, from 3 to 7 p.m. at Grace Church, Middleburg Heights, Ohio. His funeral was August 15th at 10:30 a.m. at Grace Church. There is actually a video of Davion's service online. His parents spoke, his sisters, or one of his sisters, Divine, spoke. I'm not sure if Dahlia spoke or not. But it's really kind of an amazing service. He was also interned at Strongsville Cemetery on August 29th. A search warrant was issued for the Toyota Camry. And again, all the criticism of the investigation by the Shirillas, they're taking their time,
Mm-hmm.
because it's almost a month later and she's not in custody. She hasn't been charged. She's still free to do whatever she wants to do, including attending a concert wearing a very inappropriate outfit for somebody who's mourning the loss of the love of her life,
Right,
sitting in a
because
wheelchair. I don't
Is
know
this the
exactly when
one?
that concert was, but
Is this the one where she's dressed up like a skeleton, or was that
no,
Halloween?
no,
that was
that's later.
Halloween. That was Halloween.
Yeah, because I don't know about
What?
any of you, but when I lose someone I love very dearly, the one thing I think about is let's go to a concert.
Yeah.
Exactly. What was she wearing? I don't recall. I don't think I've seen
She
this
was
picture.
wearing a bikini top and
Oh,
little booty shorts,
While in a
and she was
wheelchair.
sitting in a
oh,
wheelchair
jeez.
with her legs crossed on her phone.
Oh, jeez. Yeah, you can
And
just see the psychosis oozing.
of course, if you listen to her family, oh, but she had been in her room crying and only listening to his music and only eating his food, and so we made her go to we tied her up and took her to that concert against her will.
They've never made her do anything.
Yeah,
Yeah,
I
that's a
know.
great point.
Exactly.
They never made her do anything.
They've never made her be respectful to people. They've never made her watch her language. They've never made her not do drugs. There was prostitution, which she apparently got into with a friend of hers.
So wait,
And
that's real? Like she was a
mhm,
hooker too?
yeah, she
Oh
through
my
her
goodness, I
through her
missed that.
Snapchat. through her Snapchat.
Lordy.
I mean, price and what she'll do, and there was also an argument at some point with Dom, where she's like, "Well, he only fucked my feet." Like that makes it better.
Oh my gosh.
Yeah. I know. Well, see, that's what I'm saying. Deep dive, dark deep dive.
Mm-hmm.
Have at it. And the vehicle was again inspected on August 30th, 2022 by Fire and Explosion Consultants LLC. They were examining the 2018 Toyota Camry for mechanical and or electrical systems to determine if a malfunction may have existed that caused or contributed to the inability to properly control the vehicle, including but not limited to the steering, braking, and acceleration. They issued a report on September 9th, 2022. They noted that a safety recall for the vehicle was completed on June 16th, 2022 at Brunswick Toyota. They said that following a thorough and complete evaluation of all remaining evidence in this case, and based on my knowledge, training, and years of experience as a forensic mechanic, it is my professional opinion that the examination of the subject vehicle revealed impact-induced damage to the steering, suspension, braking system, engine, and throttle systems of the vehicle, as well as structural damage through nearly the entire vehicle. The examination of the vehicle did not reveal any evidence of fault or defect that may have caused or contributed to the inability to properly control the vehicle concerning steering, braking, or acceleration. It is my opinion that the vehicle was free of defect at the time of the event and showed no evidence of a malfunction causing or contributing to the event. A coroner's verdict was issued on September 12th, 2022 for Davion Flanagan, ruling his manner of death as an accident. A medical examiner's report was issued on October 12th, 2022 for Dominic Russo, also citing the manner of death as an accident. An arrest warrant was issued on November 4th, 2022 by the Strongsville Police Department at 1425 for Mackenzie Shirilla. She was arrested on November 4th, 2022 in Broadview, Ohio. Apparently, she was going to or coming from a doctor's appointment. She was held in custody of the Cuyahoga County Juvenile Detention with a $500,000 bond. An accident reconstruction was done by the Ohio Highway Patrol on December 7th, 2022. They completed a time and distance analysis based on available video footage. Forensic mapping was performed at the crash site on December 8th, 2022. An accident reconstruction report was issued on January 6th, 2023. And I'm not going to go into all of it. I thought I was, but basically the opinion was that the vehicle averaged approximately 80.51 miles per hour in the final second leading up to the collision as it traveled off the roadway, struck a commercial sign and the eastern side of the Plidco commercial structure. On March 20th, 2023, the Strongsville, Ohio Police Department provided additional information developed during the investigation of the medical examiner and requested a review of the manner of death for Davion and Dominic. On April 12th, 2023, the manner of death was changed by Dr. Joseph Filo, who advised by phone that after a secondary review, he was amending the manner of death for Dominic and Davion from accidental to homicide. On May 31st, 2023, the amended medical examiner's reports were issued by the Cuyahoga County Medical Examiner's Office. And then on November 30th, 2023, the Ohio State Patrol issued another reconstruction report from EDR analysis. And they said the question was posed due to observation from the surveillance footage. It appears that prior to making contact with the building, the brake lights were active as shown in the screenshot above? That question appears to have been answered by Sergeant Fox from OSHP. The following is directly taken from his report. A vehicle sheet was run through the Toyota service lane system to determine the safety features that were equipped on the Camry involved in the crash. The vehicle was equipped with several collision systems as shown below, and that was a Toyota Safety Sense P pre-collision system with pedestrian direct detection, dynamic radar, and lane departure alert. Per the Toyota master technician, as well as various Toyota demonstration videos, these systems use various radar and camera systems to provide assistance with crash avoidance. Most of these features involve slowing some or all of the vehicle's tires to maintain control and or a safe distance from a vehicle or object ahead of the Toyota. When these systems become active, the vehicle will not increase speed, but rather decrease speed. As a result, the system will activate the rear brake lights to indicate the possible slowing of the vehicle to other motorists, even if the driver is not pressing on the brake pedal. Toyota Safety Sense P works at speeds of 7 miles per hour to 110 miles per hour, but it does not work with objects that appear in front of the vehicle without prior detection. With the availability of the Safety Sense P system and the extreme driver input for the vehicle prior to the collision, the brake light activation is likely the result of the safety systems working to avoid the impact ahead or return the vehicle to a straight orientation for the direction of travel. With the information obtained by Sergeant Fox, it would explain the brake lights activating without any corresponding data in the EDR report to show activation of the service brake. So that's been a question that I've seen on social media, and that answers the question. The safety systems on the vehicle try to slow it down, try to, avoid the collision,
Right.
which was impossible. Because Shirilla was intent on doing it. Were you about to say something, Rick?
Oh no, I'm completely agreeing with you. You know, I mean, in that span of time and the acceleration, and there was no chance that there was there was going to be an intentional slowdown.
Mhm.
And I believe anything like we've mentioned before, all this with going from drive to neutral and back to drive and things like that. I think you can infer that one of the men, whether it was Dom or Davian, was trying to stop
Yeah.
Shirilla from doing what she was doing, which also would indicate that they knew what was happening before it was about to happen.
hmm
Yeah, well, and
Oh,
two, all the safety features, like you said, that if she had passed out and blacked out, the safety features would have stopped the car, and the boys would have stopped the car, right? They would have thrown it in
yeah.
neutral,
Yeah. And it wouldn't have been put back in drive.
right? And it, yeah, it would. I've never known somebody that passed out that continued to accelerate.
hmm Yeah. All right. So then we go to the criminal cases. Uh, Venue was initially in the Cuyahoga County Court of Common Pleas Juvenile Division. Case entitled in the matter of Mackenzie Shirilla, State of Ohio versus Mackenzie Shirilla, case number DL221111363, before the Honorable Jennifer L. O'Malley. Mackenzie Shirilla was represented by James J. McDonald, who was retained by her parents. How they retained an attorney when they were in bankruptcy at the time, I don't know.
It's kind of the same way that Carmelo Anthony's family declared bankruptcy despite, or he's indigent now, despite raising $1 million from the gullible public.
And they're still trying to raise money for him, I know.
Hmm.
But anyway, of course, it's the argument is that's not his money, that's his mama's money. The state was represented by Timothy Troop, Allison Kupak, and Stephen Rocco Vernia. Complaint of delinquency was filed on November 4th, 2022. The charges were 2 counts of aggravated murder, 2 counts of murder, 2 counts of felonious assault, 2 counts of aggravated vehicular homicide, drug possession, and possessing criminal tools because she had a scale in her possession. Motion for an order to relinquish jurisdiction was filed by the prosecutor on November 7th, 2022, seeking transfer to the General Division of the Cuyahoga County Court of Common Pleas. Notice of mandatory bind over was also filed on November 7th, 2022 by the prosecutor requesting a probable cause hearing. The probable cause hearing was held between March 2nd, 2023 and March 16th, 2023. The probable cause finding was made around March 17th, 2023. The Judge O'Malley found that the state failed to establish probable cause for aggravated murder. However, the state did establish probable cause for the remaining offenses, including murder, felonious assault, aggravated vehicular homicide, drug possession, and possessing criminal tools. And Judge O'Malley bound the case over to adult court for prosecution on those charges. So the case was transferred on March 17th to the Cuyahoga Court of Common Pleas, General Division. It was assigned docket number CR 23679612A before the Honorable Nancy Margaret Russo, who is no relation to the Russo family. Russo in that part of Ohio is apparently the Italian Smith or the Italian Jones. And multiple people have that last name and they're not related, or it's distant relation back in the old country. Because Russo's a common last name in that northern Ohio, correct?
I would say so, just as much
Okay.
as Smith.
Okay. Shirilla was still being represented at the time by James J. McDonnell, and the state was represented by Timothy Troop and Allison Kupak. Shirilla was indicted on March 24th, 2023, on 12 counts. Count 1, murder of Dominic. Count 2, murder of Davion. Count 3, murder, offensive violence as to Dominic. Count 4, murder, offensive violence as to Davion. Count 5, felonious assault Dominic. Count 6, felonious assault deadly weapon Dominic. Count 7, felonious assault Davion. Count 8, felonious assault deadly weapon Davion. Count 9, aggravated vehicular homicide Dominic. Count 10, aggravated vehicular homicide Davion. Count 11, drug possession. And count 12, possessing criminal tools for the scale. And I've seen a lot of mention of this too. Just because the judge in the juvenile proceeding did not find probable cause for aggravated murder, which would have been a capital offense, and because she was only 17, she wouldn't be eligible for the death penalty, but she would probably be eligible for life without parole. Doesn't mean that this wasn't a murder. Although I see a lot of Shirilla supporters arguing that. Kind of like looking at one issue and saying, see, she's not guilty. But it's like that has nothing to do with her criminal trial.
Right.
She wasn't charged with aggravated murder when she went to the adult, court. She was arraigned on April 13th, 2023, pled not guilty, and her bond was continued at $500,000. And it appears, from what I can gather, that she remained in custody in the juvenile facility during the entire time pending her trial. There was a final pretrial and bond hearing held on April 26, 2023. A pretrial was set for May 25th, 2023, and another one was set for June 21st, 2023, which were probably like status conferences. Defendants' expert reports were due on June 30th, 2023. A final pretrial was set for July 19th, 2023, and trial was set for August 7th, 2023. Bond was continued at $500,000. But I believe she remained in custody because her parents couldn't post that bond. An order was entered on May 4th, 2023, setting a discovery cutoff of July 12th, 2023. The pretrials were held on the 25th of May and the 21st of June, and another one was set for July 6th, at which time they pretrial was held on July 6th. The final pretrial was set for July 19th, as previously set, and plea negotiations were ongoing. However, I suspect that they were pushing for some kind of non-felony, maybe like I'll take the drug charges, but I won't take any of the murder charges and the vehicular charges. And it was pots, it was pots, it was pots. So on July 12th, 2023, the defendant was to be returned to the Cuyahoga County Jail on July 19th, 2023 for the final pretrial plea in courtroom 18C. The final pretrial was held. The trial remains set for August 7th, 2023. A plea offer was placed on the record by the state and rejected by the defendant, but unfortunately, I don't know what the plea offer was. And it's not available in the online records. So I would love to get my hands on it, but it's just not in the cards. An order was entered on August 3rd, 2023. State's motion to view the accident site was granted, or the crash site was granted. And on August 4th, the state filed a motion to introduce other acts evidence pursuant to Evidence Rule 404B, which I suspect was the burglary, breaking and entering, menacing, the road rages, the drug use, the reckless driving, because she videoed herself driving recklessly many times. Rick, is there any chance you can look at the one of the videos at the scene, the body cams? Can you look at that and tell me if her furry vehicle wheel cover was on the vehicle at the time?
I believe it was.
Okay.
If you need me to take a look at that now, I
If you could
can.
take a look at that and tell me if the wheel cover was on,
Okay.
because I have a theory.
Okay.
I'm gonna continue on with the trial.
No problem.
I'm
I'm gonna.
excited for this theory.
um, so the case goes to trial. Counsel for the state is Timothy Troop, Allison Kupak. Counsel for the accused is James J. McDonald. And on August 7th, 2023, the defendant made a voluntary waiver of jury trial and order, which was entered on the record in open court. So I suspect, because I don't have the defense file, that A, he couldn't find an expert who could attribute the crash to a medical event. And
No, because one
B,
doesn't exist.
and B, that he was afraid with all the extraneous things that the state planned to introduce that she was not going to fare well with a jury, especially the text between her and Dom and the things that she said to Dom
Yeah,
during.
because I've heard people make the comment that it was a mistake to not do a jury trial, but I think that's probably wrong. I think they probably thought maybe a judge would be, I don't know what the right word is, more
More exacting.
sophisticated and yeah, more
Yeah.
exacting and to be able to kind of understand this sort of crazy ass theory that she had a medical condition.
Oh, well, that poor Kyle. Kyle just got cut off. We'll watch for him to come back. But yeah, I don't think that she would have fared well with a jury. And I think that Mr. McDonald did think that the judge would be more exacting of the state's evidence and the state's case as to intent, because the state did have to prove that it was an intentional act. The crashing the car was an intentional act. All right, let me put Kyle back on the stage. Hello, Kyle. What
Oh, sorry.
happened?
My phone is just possessed. I literally it just is possessed. I have no other explanation.
All righty. So you were right in the middle of a thought.
Yeah, so I was just saying, I think there seems to be some group online that says, oh, that was a mistake, but I think she probably had a better chance with a judge than she would have had a jury, especially, all the text and everything else, as you were mentioning.
Yeah, I totally agree. Um, I think that, and I think that he thought they had a better chance on the murder counts with a
Yeah,
judge. That a
right, I
judge
agree.
would not find murder, but she might find vehicular homicide.
Right.
Um, but she did voluntarily waive it. It was done in open court. It wasn't, her parents make it sound like, she was a dumb 18-year-old and she was bullied into it by the attorney. And Steve Shirilla is like, well, he wouldn't let us be there. You can't be there. She's 18. If you're there, there's no confidentiality. There's no attorney-client privilege because you're third parties.
Right.
That's why you couldn't be there. And you're supposedly some, educated, smart man, but you don't know that. You think because she's your child, you're entitled to be there, and everybody can pound sand if they don't like it. If they'd been in any attorney-client meetings, there'd be no privilege.
Yeah,
And
absolutely. I
she
mean,
could be compelled, they could be compelled, the attorney could be compelled.
yeah, I mean, you can't even get your 18-year-old child's, medical records.
Mhm. Yeah. So, anyway, they also entered stipulations on the record on August 7th, 2023, that Shirilla was the person who was driving the car at the time of the crash. An order was also entered on August 7th, 2023, granting the state's 404B motion. Unfortunately, the motion that details exactly the evidence that they wanted to enter was not available online. Um, Ohio court system has a lot available, but some of the state's documents are never available. I don't understand. But anyway, uh, so I don't know exactly what, but I'm suspecting the text. She made threats to kill him. She was just a nightmare to deal with. The indictment was amended without objection on August 7th, 2023. The original indictments referred to Dominic and Davian as DR and DF, and the amendment was made in trial to refer to them as Dominic and Davian. That's all it really was. The trial was held from August 7th to August 10th. The state rested. Shirilla's attorney made a Rule 29 motion, which is like a motion for directed verdict. It was denied. And then the judge said that she would give her verdict on August 14th, 2023. The hearing was held on August 14th, 2023, and the verdict was rendered. She was found guilty on counts 1 through 11, um, which I think is actually, I think she was also found guilty on count 12, but for some reason, the listing I had was 1 through 11. Sorry. Um, the sentencing memoranda were due August 17th, 2023, or the judge said deadline for sentencing memoranda, and then set sentencing for August 21st, 2023. That verdict is available online. You can watch it on YouTube. It's very informative and very interesting, and it became the subject of a call between Shirilla and her mother. Um, and that call just proves how very tone deaf those three people are, because they like the time to be vindictive and ugly has passed. Now you should be contrite. You should show remorse. You should be sorry. You should be sorry. But no, not them. Sentencing was held on August 21st, 2023. An agreement had been made prior to that hearing that counts 3, 5, 6, and 9 would be merged in count 1, and counts 4, 7, 8, and 10 would be merged with count 2. Shirilla was sentenced to 15 years to life on count 1 and count 2 each, but the sentences are concurrent, not consecutive, which again shows that the judge did have some mercy for Shirilla, because she could have sentenced her to 15 to life consecutive. And that would mean she'd do 30 years before she'd be eligible for parole. However, the judge also suspected that she would spend the rest of her life in prison, because she made a comment to that effect. And then
Really?
she
That's
was,
interesting. So the
yeah,
judge doesn't think she would get parole.
yeah. And again, the sentencing is available online, and you can watch it online. And when Natalie Shirilla comes up to talk, it's just like, it's so tone deaf. It's like she's trying to make excuses, as she's always done. So the Halloween thing, that wasn't Mackenzie's idea. That was her parents' idea, because she had been pining so much over Dominic. And apparently dressing like a corpse was also part of the thing.
Lisa, update.
Yes.
So I know, so I was looking at the video, and I know this is kind of a contentious online debate, but as I was looking, and keep in mind, the video is like about 57 minutes,
Yeah.
but any chance of possibly seeing that furry or that fuzzy steering wheel cover
Uh,
is blocked by two things. One, it's blocked by blurry images because they're trying not to show the bodies, but the
yeah.
blurry image is pretty sizable. Also, I believe if from the way that my eyes are interpreting it, it looks like the safety bags also would be covering that a little bit.
Okay.
So I was looking, but I also decided, like, well, let me do a little bit more research on that. But I understand it's a contentious point apparently on an online debate, but there was nothing conclusively that I saw, unless
Okay.
there's a law enforcement, a detective can mention that, or
I'll have to look at that. I'll look at, because I know I have a vague recollection of looking at one of the videos after Mackenzie was taken out and somebody was photographing the car.
mhm.
It might be in the still photos of the vehicle.
And it might be, and I could have, again, it could be one of those like memory things where you think you saw
Yeah.
something and you
Yeah.
didn't, and
Because
because I thought I did see it too.
well, no, see, I have a vague recollection of a picture where that cover is not on the steering wheel after the accident.
Hmm.
And that's the kind of thing Mackenzie would remove that, because she knew she was going to destroy the car,
Hmm.
and she wanted to have it for her next car, because
Interesting.
the little bitch was planning on getting another car.
Right.
So, but what I'll do is I'm going to look at the some of the crime scene photos of the vehicle, and like the forensic investigation photos, and see if I could see whether it was on the steering wheel or not.
Okay.
So anyway, Shirilla was sentenced for count 11 to time served and count 12 for time served. She received jail time credit of 292 days. Eric M. Levy was appointed as her appellate counsel, so Jim McDonald was removed as her appellate counsel, and her driver's license was suspended for life, as to counts 9 and 10, which I believe were the vehicular homicide. On August 22nd, Eric M. Levy filed a notice of appearance on behalf of Shirilla. The report of her license suspension was sent to the Ohio Bureau of Motor Vehicles on August 23rd, 2023. And a notice of appeal was filed on September 11th, 2023. The trial transcript was completed on October 23rd, 2023, the case went to the Ohio 8th District Cuyahoga County Court of Appeals, case number CA 23-13167. Judges were Eileen A. Gallagher, Emanuela D. Groves, and Frank Daniel Celebresi III. Attorneys, counsel for Shirilla were Eric M. Levy and Eric C. Nemechek. He appears to have also been retained, and I believe Mr. Levy withdrew. The state was represented by Michael C. O'Malley, Anthony Thomas Miranda, and Kristen L. Sobieski. A notice of appeal, again, was filed on September 11th. The record on appeal was filed on October 24th, 2023. Levy was withdrawn, and Nemechek was substituted on October 24th, 2023. On December 15th, 2023, transcripts of the juvenile court hearings were filed. Appellant's brief was filed on January 2nd, 2024. The issues raised were that the juvenile court erred when it concluded that the state presented sufficient credible evidence to demonstrate probable cause to believe that Shirilla purposely and or knowingly caused the deaths of DR and DF. The state failed to introduce sufficient evidence to sustain the convictions in violation of Shirilla's right to due process of law as guaranteed by Article 1, Section 10 of the Ohio Constitution, as well as the 14th Amendment of the U.S. Constitution. Shirilla's convictions are against the manifest weight of the evidence. The trial court erred by permitting the state to introduce character and or other acts evidence during its case in chief, thereby depriving Shirilla of a right to a fair trial in violation of the United States and Ohio constitutions. And the trial court erroneously precluded the defense from introducing testimony and or evidence relating to the July 17th incident, thereby prejudicing Shirilla's constitutional right to due process and a fair trial, as well as her right to present a meaningful and complete defense. And what they were trying to do was they were trying to ask witnesses other than Christine Russo about Shirilla's text to Christine Russo claiming that it was Dominic who was trying to crash the car on July 17th. So those attempts were objected to and the court upheld the objections. They weren't trying to ask Christine Russo about that. Of course, probably because they knew that Christine Russo would be like, that's a self-serving statement. I don't believe her. But that's what that is about. Appellee's brief was filed on March 21st, 2024. They argued the state presented sufficient evidence to believe that Shirilla purposely killed DR and DF in support of counts 1 and 2, purposeful murder. The state presented sufficient evidence to believe that Shirilla knowingly caused physical harm to DR and DF, supporting counts 3 through 8, felony murder, and felonious assault. Oral argument was held on May 28th, 2024. An order was entered on May 30th, 2024. It said the parties are hereby ordered to brief the issue of whether or not there was compliance in the matter with RC-313.19 and the effect, if any, on the arguments of error and or verdict if there was no compliance. The supplemental briefs are due 10 days from this order. Notice issued, amendment of, and this is regarding the amendment of the manner of death on the medical examiner's reports. A supplemental brief was filed by the appellee on June 10th, 2024. They argued that Shirilla forfeited any challenge relying upon RC 313.19, that it only applied when third parties seek to challenge the coroner's determination. It does not apply when the coroner decides to change its own determination. That binding case law renders RC 313.19 of no legal effect. RC 313.19 does not relate to Shirilla's assignments of error. The appellant filed her supplemental brief on June 10th, 2024. They argued the autopsy reports, verdicts, and death certificates were improperly amended. Shirilla's Sixth Amendment right to confrontation was violated by the omission of testimony and evidence concerning the amended autopsy reports, verdicts, and/or death certificates. The admission of testimony and evidence concerning the improperly amended conclusions is relevant to the assignments of error set forth in appellant's merits brief and served to irreparably prejudice Shirilla's constitutional right to due process of law and a fair trial such that reversal is warranted. The appellee filed a motion to strike appellant's post-hearing brief, or in the alternative, motion for leave to respond, because apparently there was another brief filed. It's not available online, and so I don't know what it had anything to do with, but the state moved to strike it or requested a chance to respond. Because they wanted to strike that brief because it raised the confrontation clause issue. Sorry,
Lisa,
people.
no, that's okay. And Lisa, real quick, because the whether there was a fuzzy wheel cover during the crash or not was bugging me. I sent you a text, but I did a quick search, and from what I can see, no, that cover is not on.
Okay.
And then I also sent you a link of a video too. So I don't know when that particular picture was taken. I don't know that. I don't know if there'd be a reason to remove that. But just based on the photo alone, that's all I'm going on. There's no fuzzy wheel cover.
Thank you. I recognize that. That is the picture I was thinking of.
Yeah, that's
And it
definitely
may
interesting.
be visible in one of the later body cam videos.
Could be, but yeah, I don't know.
But
But
if
yeah, I
not, your
saw
theory
that.
makes sense.
Yeah, yeah. So the fuzzy wheel cover was not there.
Not based on the photo that I see.
So, all right, great. Okay. So, they sought to strike the brief because it raised the confrontation clause issue, or they sought chance to leave to reply. On June 12, 2024, the appellee's leave to respond to confrontation clause claims and appellant's post-hearing brief was granted. The appellee filed their supplemental brief on June 14th. They argued that Dr. Joseph Filo was personally involved in the changes to the autopsy reports after receiving information from the police investigation. Dr. Filo testified at trial in this case, therefore, there is no confrontation clause issue with respect to the amended autopsy reports because Dr. Filo was confronted at the trial in the form of cross-examination. Even if the court finds some confrontation clause error, any error was harmless beyond a reasonable doubt or failed to rise to the level of plain error because autopsy reports and testimony from forensic pathologists ultimately added very little to the debate of whether the crash was an accident or done on purpose. The opinion was issued on September 26, 2024. Basically, they overruled all of Mackenzie Shirilla's assignments of error. And I'm not going to go into the to the reasoning for everyone, but they did find that in this case, the change of manner of death of Davion Flanagan and Dominic Russo by the office of the Cuyahoga County Medical Examiner did not affect the verdict in this case. Although the trial court had before it evidence of the change as to the manner of death of the Cuyahoga County Medical Examiner's office, there was other evidence to support the verdicts. Finally, in light of precedent from this court, any error in the procedure under the circumstances would not be obvious. This court has held that RC 313.19 contemplates situation where a third party seeks to have a trial court direct a coroner to change the manner of a person's death, unlike the situation here. Having overruled Shirilla's assignments of error for the reasons stated above, we affirm. A certified copy of this entry shall constitute the mandate pursuant to Rule 27 of the Rules of Appellate Procedure. Shirilla filed an application for reconsideration en banc consideration on October 7, 2024, arguing that the failure of the state and or the medical examiner's office to comply with Ohio RC section 313.19 was obvious error, and that the error affected Shirilla's substantial rights and or resulted in a miscarriage of justice. Appellee filed a brief in opposition to that application for reconsideration and en banc consideration on October 15th, 2024, and argued that appellant merely reiterates arguments she previously made in the supplemental briefing and which this court rejected. The statute is not implicated where the manner of death is willingly changed by the medical examiner himself after he reviews additional information. A journal entry was filed on October 18th, 2024, denying the application for reconsideration. At App R26 reconsideration was not designed to be triggered by a party's dissatisfaction with the outcome of an appeal. An application for reconsideration is not intended to simply allow a party to challenge an opinion because of a disagreement with the conclusion reached and the logic employed by the appellate court. As stated above, Appellate Rule 26 applies when an obvious error exists or an issue was not considered or not fully considered by the court. This is not the case in State versus Shirilla. Appellant's application for en banc consideration remains pending. And then on December 31st, 2024, a journal entry was filed. The matters before the court on appellant's application for en banc consideration pursuant to Appellate Rule 26 and McFadden versus Cleveland State University, we are obligated to resolve conflicts between two or more decisions of this court on any issue of law that is dispositive of the case and in which en banc consideration is necessary to secure and maintain uniformity of this court's decision. Upon review, a majority of the judges of the en banc court find no conflict on a dispositive point of law between the panel decision and the prior decisions from this court. Appellant's application for en banc consideration is denied. Shirilla filed a notice of appeal to the Ohio Supreme Court on February 14, 2025. That was assigned case number 2025-0252. Her notice of appeal was also filed. She filed a memorandum in support of jurisdiction, alleging that this appeal involves substantial constitutional questions and or an issue of great public importance. And then proposition of law number 1 was conviction under RC 2903.02 requires proof that the defendant undertook actions with the specific purpose or intention of causing the death of another. Proposition of law number 2 was a juvenile's right to due process is violated when charges that are not supported by probable cause are bound over to the common pleas court. Proposition number 3, the state is not exempt from complying with the procedure set forth in Ohio RC 313.19. And proposition of law number 4, failure to comply with the procedure set forth in RC section 313.19 constitutes plain error. The error was obvious and the error affected Shirilla's substantial rights and or resulted in miscarriage of justice. The state responded on March 10th, 2025. They basically argued that appellant's propositions of law do not present a substantial constitutional question or issue of great public or general important interest. Rather, strong evidence exists of appellant's purpose to kill. Appellant never challenged in the trial court the Cuyahoga County Medical Examiner's decision to change the victim's manner of death in this case, and therefore she waived all but plain error. The 8th District correctly recognized that 313.19 was inapplicable, and the 8th District correctly declined to recognize plain error in the underlying case. A dispositive decision was entered on April 29th, 2025, via journal entry that upon consideration of the jurisdictional memoranda filed in this case, the court declines to accept jurisdiction of the appeal pursuant to Rule 7.08b4. So her conviction became final. Her conviction and sentence became final on July 28, 2025, which was her deadline to file a petition for writ of certiorari to the U.S. Supreme Court, which she did not do. And then the case goes back to the Cuyahoga County Court of Common Pleas General Division. in the original criminal case before the Honorable Nancy Margaret Russo. Shirilla is represented by Eric C. Nemechek, and the state is represented by the Cuyahoga County Prosecutor's Office. On October 24th, 2024, um, Nemechek files a motion to vacate or set aside convictions. And he basically is arguing that trial counsel rendered ineffective assistance, thereby depriving Shirilla of her right to due process of law and a fair trial under both the United States and Ohio constitutions. They argue that he failed to conduct an adequate and independent investigation to support the defense's theory of the case, including Shirilla's medical condition, the July 17, 2022 incident, and the testimony of Allison Grollo. Shirilla suffered prejudice as a result of trial counsel's deficient performance regarding her medical condition, the July 17, 2022 incident, and the testimony of Allison Grollo. There was an affidavit signed by Shirilla on October 24, 2024, that she retained James McDonald with the assistance of her family to represent her at trial. She had limited communication with McDonald. During all interactions, she vehemently denied the allegations and then maintained that she did not harbor any ill will toward Dominic or Davion, nor would she intentionally or purposefully crash her vehicle on the night of the incident. She consistently expressed her intention to defend the allegations at trial. She informed McDonald that she was diagnosed with POTS in or around 2017. Her family provided McDonald with copies of medical records to introduce at trial. Now, those medical records are single-page reports. They're practically illegible. And one of them has things that actually are not helpful to Shirilla. Because and let's talk about this real quick too. As thin as she is, if she's anorexic or bulimic, that can cause issues with fainting, losing consciousness, seizures. The drug use can cause fainting, losing consciousness, seizures. I mean, the POTS diagnosis is kind of ephemeral because they didn't mention the POTS diagnosis when she got her driver's license. And they didn't mention the POTS diagnosis or suspecting POTS as a cause of the crash when she renewed her driver's license shortly after the accident or the crash. And it's funny because at one point somebody said something about that to her mother, and her mother said, "You don't have to disclose that." It's like there's a question: do you have any medical condition that makes you lose consciousness?
But you would think, if they know that she had POTS, that there would be a concern about putting their daughter behind the wheel. Now,
Yeah.
granted, they've allowed a lot of other stupid things, but you would just think, as loving parents, you wouldn't want your child to get behind a wheel if POTS is such a significant thing to her condition to where she'll get a dizzy spell and pass out, which is also different than seizures, which is, something that when they were speaking in Kearney to her mom in front of the detective when she was being questioned, that
Yeah.
was one of the things that, like, well, can we just say it was a seizure? So is it a seizure or is it POTS? Which is
Yeah. And POTS, the first word in that is positional, which means when you go from seated to standing, you pass out.
right.
I think it has something to do with tachycardia, which is a heart rate going too fast. But she was seated in a car. She's not changing positions.
Right. And with POTS,
Now,
like
maybe she had a rage blackout because she was raging at Dominic. We don't know.
Mhm.
I mean,
But
even
even
that's not going to cause her to accelerate the vehicle, give it 100% gas, and run into a sign and then a building.
well, and that's another thing too. Like with POTS, where does it show that you would get some kind of stiffening that it would make you accelerate
Yeah.
the pedal,
Yeah.
right? You
Yeah.
would think, if anything, that would actually slow it down. Now,
Right.
a seizure would be different, and that was one of the things that she mentioned, but there's nothing to indicate that she had a seizure. And POTS and seizures are completely two different things.
Yeah. Um, she said McDonald did not make any effort to retain an expert witness to review the medical records or other discovery material to determine whether the evidence was consistent with the theory that the accident was caused by a medical condition. McDonald did not introduce the medical records confirming the POTS diagnosis at trial. Um, she discussed a prior incident with Dominic that occurred on July 17, 2022, and advised McDonald that she didn't threaten or attempt to crash the vehicle during the course of that argument. She informed McDonald that Dominic grabbed the steering wheel while she was driving and attempted to crash the car. She also told McDonald that there would be text messages on her cell phone corroborating her recollections of the July 2022 incident. Well, yeah, there are self serving text messages to Dominic, and I don't believe them. It looks like an abuser blaming his victim or
Right.
her
It's
victim.
it's manipulation. She's trying to tell other people her side of it so they feel bad for her and put it all on Dominic. I mean, that's
hmm
what's happening.
During the pre-trial stage of the case, her family provided McDonald with copies of text messages between herself, Dominic, and Christine Russo regarding the July 17, 2022 incident. She reviewed the text messages and discussed their significance to her defense. There were several text messages that proved that Dominic admitted grabbing the steering wheel and attempting to crash the car, which is not true. But she authenticated the text messages. McDonald noted the significance of the text messages and expressed his intention to introduce the relevant text messages during trial. In spite of the significance of this evidence to a successful defense, McDonald failed to undertake any investigation into the matters, including retaining a medical expert and introducing the records confirming her POTS diagnosis at trial. McDonald failed to introduce the text messages that contradicted the state's claim that she threatened or attempted to crash her vehicle on July 17, 2022, during the course of an argument with Dominic. She admits that she and Dominic had disagreements during the course of their relationship, but says they were very much in love at the time of the accident, and I had no desire, intention, or reason to cause him or anyone else harm. Now, the text messages, again, they're refuted as to part of it by Christopher Martin, who heard Mackenzie say, I'm going to crash this car. Of course, the Shirillas, they're the only ones telling the truth,
Of
and
course.
everybody else is lying. That's kind of their shtick. Then we have another affidavit of Allison Grollo signed again on October 24th, 2024. She testified during the defense's case in chief. She owned Allison's Superfoods Market, a produce market located at 12966 Prospect Road at the time of the accident. Her business had been in operation since February 2017. Some customers placed grocery orders that were picked up at a later date or time. If the customer was unable to get to the market during normal business hours, the order was placed in one of the lockers outside of the building. The lockers were checked daily to ensure that all orders had been picked up. She'd gotten to know Dominic and Shirilla on a personal level for the year before the accident because they were regular customers at the market. She would engage in conversations with them when they came to the market to shop, and she communicated with Shirilla via text messaging. She saw Shirilla and Dominic at the market on the evening of July 30th, 2022. Keep this in mind. There was another individual in their company she did not recognize. They had a brief conversation before she left the market. She did not observe anything out of the ordinary or concerning about their interactions. They appeared to be in good spirits and enjoying each other's company. Later that evening, she received a text from Shirilla indicating that they forgot to purchase potatoes when they were in the market that day. Shirilla asked if someone would put a bag of potatoes in a locker for her to pick up after hours. Shirilla told She told Shirilla that would be fine and instructed one of her employees to place potatoes in a locker. When she arrived on 7/31/2022, she checked the locker and the potatoes had not been picked up. Was asked to testify at trial by McDonald, and she briefly spoke to him prior to testifying. She advised McDonald of the facts set forth in the affidavit, including that she saw them on July 29th, 2022, as well as the subsequent text message regarding potatoes. At trial, McDonald did not ask about her interactions with Shirilla and Dominic on July 29th, 2022. Had those questions been asked, she would have testified consistent with the statements in the affidavit. She had lived in Strongville for 8 years and was familiar with the area, including the location where the accident occurred, the intersection of Alameda and Progress Drive. Progress Drive is frequently used as a cut-through street, particularly by other residents of Strongville. She drove through the intersection where the accident occurred on her way to work and on her way home every day for 7 years to avoid the traffic in the town center. She was aware of the testimony and evidence concerning the crash that formed the basis of Shirilla's criminal charges, including the route the vehicle was traveling and the location where the accident occurred. At the time of the accident, Shirilla's vehicle was traveling in the direction of the market. Provided Shirilla's appellate attorney with a copy of the text messages that she sent to and or received from Shirilla on the evening of July 30th, 2022, and authenticated those texts. So was it July 30th or was it July 29th?
Right.
And if you're telling the attorney July 30th and July 29th, that's probably why he's not going to ask you about it. And it doesn't explain July 28th.
No, it doesn't.
Journal entry was made on October 28, 2024, setting a response, requesting a response from the state on January 6, 2025. Shirilla filed a supplemental petition on October 20th, 2024, with additional evidence from a medical expert regarding the defense's POTS theory. On December 26, 2024, the state filed its brief in opposition to defendant's motion to vacate or set aside convictions. That's not available online, so I'm guessing the arguments were that it was not timely. On January 16, 2025, a journal entry was entered striking the supplemental pleading, which was filed without leave and during the response time granted by the state. I must have this was a motion to strike. Sorry, the state filed a motion to strike the supplemental petition. Sorry, guys.
It's okay.
And it's not available, so I don't know. But I think it was because they didn't seek leave to file it. Should defendant wish the court to consider any documents or arguments outside the first petition, they are ordered to move to withdraw and file a completed petition or file leave to supplement. Counsel further advised that all pleadings in excess of 5 pages requires a courtesy copy to be delivered to the court. Motion for leave to supplement was filed on January 20th, 2025, seeking to file documents and the supplemental petition. The state filed a brief in response to that motion, in which they said they didn't oppose it. That was on January 22nd, 2025. Shirilla filed a renewed motion for leave to supplement her petition for post-conviction relief on March 11th, 2025. A journal entry was made on April 1st, 2025, granting that motion and requesting a response from the state on by June 9th and saying that there would be no reply briefs. Petitioner's first amended supplement to petition for post-conviction relief was filed on April 3rd, 2025. It's not available online for some reason, but it, I believe, from what I can glean, it provided expert opinion that the crash was caused by POTS or some other medical condition. Based on her oxygenation level at the time she was extricated from the vehicle, which was also after being pinned under the dashboard with broken ribs for at least an hour. State's brief in opposition to defendant's motion to vacate or set aside was filed on April 30th, 2025. A journal entry was entered on May 1st, 2025. The court has reviewed all pleadings and the law in the matter. The court finds the state's position well taken, to wit, that the defendant's petition is time barred as a matter of law, having been filed past the statutory deadline. As the filing by defendant was untimely, this court is without jurisdiction to consider the merits arguments of any of the pleadings. Therefore, as the defendant's petition is statutorily time barred and filed out of rule, the court denies the petition for post-conviction relief. So the petition is denied. A notice of appeal was filed on May 6, 2025, went to the 8th District and was assigned docket number CA-25-115101. The panel was judges Anita Laster-Mays, Michael John Ryan, and Eileen A. Gallagher. Her counsel was Eric C. Nemechek. State was represented by Michael C. O'Malley, Anthony T. Miranda, Tim Troop, and Allison McGrath. Journal entry was entered on May 7th, 2025. The motion by appellee to transfer transcripts from Appeal 113167 to the current appeal is granted. The clerk's office is ordered to transfer the transcript from Appeal number 113167 to the instant appeal. The record is due June 16th, 2025. And is amended to an Appellate Rule 9B record. The merit brief of appellate was filed on July 13, 2025. The assignments are error that the trial court erred when it concluded that the motion to vacate or set aside convictions was untimely, that any error in calculating the deadline for filing the motion to vacate or set aside convictions should be excluded under the principles of equitable tolling and or in the interest of justice. They argued that the petition was timely as the record for the direct appeal was not filed until December 15, 2023, and that the statute of limitations established by RC Section 2953.21 is not affected by a leap year. Appellee filed its brief on July 28, 2025. The response to the assignments of error was basically assignment of error number 1 response. The trial transcripts were filed on October 24, 2023, starting the 365-day clock. Appellant's petition for post-conviction relief was filed 1 day late on October 24th, 2024, instead of October 23rd, 2024. The 365-day clock started upon the filing of the trial transcripts, not the transcripts of the juvenile probable cause hearing. Applicant did not preserve her arguments. A transcript of probable cause hearing in juvenile court is not a trial transcript. Appellant relies on unavailing case law, and State versus Deaton is distinguishable and wrongly decided. Several courts have applied the 365-day period to petitions for post-conviction relief during leap years, and there is no applicable timeliness exception. And you sounded like, Rick, you were getting ready to ask a question.
No, maybe I breathed just a little too loud. I'm sorry.
That's okay. I thought you were rearing up.
No, unfortunately not.
Okay. Assignment of error number 2. Their response is the timeliness requirement for petitions for post-conviction relief is jurisdictional. The habeas statutory time limitations period is not jurisdictional and may be tolled for equitable reasons. Appellants claim that her counsel reasonably believed that the 365-day clock did not start until the transcripts from the juvenile court bind-over hearing were submitted on 12/15/2023 is unsupported by any evidence. Post-conviction counsel did not submit an affidavit explaining this alleged belief in the trial court. There is no freestanding constitutional right to post-conviction relief based on actual innocence, which is a merits claim which the trial court did not reach. Appellant had the obligation of establishing jurisdiction as an initial matter, which she failed to do. Shirilla filed a reply on August 7th, 2025, arguing that she did properly preserve her arguments and that precedent case law supports the conclusion that the petition was timely filed. And they were relying on federal, not state law. On August 8th, 2025, a cuckoo filed a document entitled The Appeal Mackenzie Shirilla Trial. That cuckoo is named Eric S. Reeve. He's a non-party. He's apparently from California. He has some type of criminal history, and he's a cuckoo. Appellee's motion to strike the 8/8/25 filing was filed on August 12th, 2025. Basically, the document in question is authored by a non-party, specifically someone residing in California who spent 10 years in penitentiaries, is currently enrolled in college, and who has opinions about the conviction in this case. Appellate dockets are not the forum for opinion columns. Instead, they are the place where parties through counsel litigate legal issues. Appellate Rule 17 provides that an amicus curiae may only file a brief if accompanied by written consent of all parties or by leave of court granted on motion. Here, there is no consent of the parties or leave granted by the court for a non-party to file a brief in this case. The clerk should not have accepted the document for filing, and this court should strike it from the docket, which they did, which I'm really disappointed because I would have loved to have read what that cuckoo had to say. Journal entry August 13th, that strikes the cuckoo's brief, and a notice was filed on December 3rd, 2025, setting oral argument for January 14th, 2026 at 1 p.m. Oral argument was held on January 14th at 2026. On March 12th, 2026, the court issued an opinion. They basically, I would love to read this whole thing, but because it really kills Shirilla. But I'm just gonna basically, I'm gonna skip to the end. I'm sorry. I bit off more than I could chew. Okay. Well, maybe I'll post in the, because the reasoning for why they're not, granting equitable tolling and they're not letting her proceed, it's all good logical reasoning, which if you listen to her family and some of the pro Shirilla pundits, they obviously have not read why. They just think it's part of a conspiracy. The conclusion, because the filing of a post-conviction petition is a jurisdictional act and the exceptions for delay set forth in RC 2953.23A1A and B are not satisfied, the trial court lacks the authority to apply equitable tolling to excuse even a one-day delay. Shirilla's post-conviction relief petition was filed on the 366th day following the filing of her trial transcript. Accordingly, we find that the trial court correctly determined it was without jurisdiction to consider the petition. Finding no error in the trial court's application of the jurisdictional 365-day mandate, both assignments of error are overruled. It's ordered that appellee recover from appellant costs herein taxed. The court finds there were reasonable grounds for this appeal. It is ordered that a special mandate be sent out of this court, directing the common pleas court to carry this judgment into execution. A certified copy of this entry shall constitute the mandate pursuant to Rule 27, and that was authored by Justice Mays and presiding Justice Ryan and Justice Gallagher concurred. Appellant filed a motion to certify a conflict on March 19th, 2026, where the 365-day deadline to file a petition to vacate under Ohio RC 2953.21 begins to run when all transcripts that are specifically requested and or deemed necessary for inclusion on direct appeal are filed with the court. She argued the majority's holding conflicts with decisions from the 1st, 2nd, and 7th District Courts of Appeals, which have held that the 365-day deadline does not begin to run until all transcripts deemed necessary for including in the record on appeal had been filed with the appellate court. So she was requesting that they certify a conflict among districts for the Supreme Court to um, decide. Sorry, I had to take a drink. um, Appellee filed a brief in opposition on March 23rd, 2026. And basically, I'm just going to name the cases she's relying on. They argued that Burke and Markham do not involve different judgments, that Barker and Porter are different because there was a plea. Markham, Porter, and Deaton did not involve transcripts of bindover proceedings, and appellant did not seek leave to supplement the transcripts. So the appellant fails to establish that a conflict exists between this court's decision and the decision of any other appellate district. For these reasons, the state respectfully opposes the appellant's motion and asks that it be denied. A journal entry was made on, March 24th, 2026, denying the motion to certify a conflict. Shirilla filed a notice of appeal on April 27th, 2026. The case went to the Supreme Court of Ohio, docket number 2026-0519. Shirilla is now being represented by John T. Martin and Stephen L. Bradley. The state is still being represented by Michael C. O'Malley and Anthony T. Miranda. Again, the notice of appeal was also filed in the Supreme Court. Shirilla filed a memorandum in support of jurisdiction on April 27, 2026. And basically, she's arguing that the bindover proceedings were a necessary part of her appeal, and therefore the time shouldn't have begun to run until those proceedings were filed. But I'm not going to go into all the reasons because it's just repetitive. The motion to certify, the order denying the motion to certify, or journal entry denying the motion to certify conflict, was also filed in the Supreme Court. The state filed a memorandum in response to jurisdiction, basically arguing that Barker and Porter are distinguishable, that Deaton is distinguishable and wrongly decided, that Shirilla did not preserve a constitutional claim, and that there was no constitutional right implicated in the post-conviction process. And again, I'm not going to go through all this stuff, but basically she's trying to rely on the federal equitable tolling principles in state court where their law is jurisdictional. Federal habeas is not. So basically in Ohio, if the thing says 90 days and you file something on the 91st day, the court has no jurisdiction to review whatever you filed. And in Ohio, it's not 1 year from the date, it's 365 days from the date, which makes calculation different. So basically, it's that a lot of the arguments she's raising in the jurisdiction, her memorandum in support of jurisdiction, were not raised before the appellate court or the trial court. Dispositive decision was entered on June 23rd, 2026 via journal entry. Upon consideration of the jurisdictional memoranda filed in this case, the court declines to accept jurisdiction of the appeal pursuant to Rule 7.08b4. She then filed a motion for reconsideration on July 26, 2026, basically re-arguing just about everything she argued in her initial memorandum. And the response to appellant Mackenzie Shirilla's motion for reconsideration was filed on July 16, 2026. And basically, it provides a really sweet smackdown. What new material issues does Mackenzie Shirilla bring to this court's attention? None. In fact, Shirilla more than once directs the court to arguments already briefed in her previously filed memorandum in support of jurisdiction. Her reconsideration motion is simply a reply to the state's opposition to her original memorandum. But if this court wanted replies to memoranda in support of jurisdiction, its rules would permit this, or permit them. Shirilla's reconsideration motion informs this court that if it will not accept the jurisdiction over her 4 propositions of law, she would prefer this court to accept jurisdiction over at least one. She then notes that if the court agrees with her on her first proposition, it will need to decide her second proposition as well. And even though her first assignment of error is now her primary focus, she does seek reconsideration of all 4 propositions of law. Reconsideration motions shall not constitute a re-argument. But this court knows that it can accept jurisdiction over some propositions and not others. It regularly does so. So Shirilla's motion repeats what she already said to tell this court something it already knows. That doesn't merit reconsideration. Shirilla's motion presents no new substance. Her memorandum already addressed what she called an inconsistency that rises to the level of certifiable conflict, but the 8th District determined its opinion did not conflict with the Second's. The state response explained why the decision was correct. Her original memorandum also made the same constitutional argument she makes in her reconsideration motion. But as the state noted in response, Shirilla did not preserve any constitutional argument. Her motion does not address this forfeiture. At bottom, Shirilla asks this court to elevate presumptive legislative intentions over the statute's plain text. To the extent she worries that meritorious claims will go unaddressed, the General Assembly has ensured that that would not happen. Ohio's post-conviction relief statutes already include an exception for untimely filings. Shirilla did not seek relief under that section, nor could she, so her concerns are overblown. This court already rejected Shirilla's supplemental jurisdiction request. It should do so again. Creating a new Shirilla-specific exception is a matter for Broad Street, not Front Street. So that's where we stand now as far as the legal process goes. The Ohio Supreme Court has not yet issued any opinion as to whether it would or would not accept jurisdiction. But when you read these briefs, you could see the manipulations there because it's trying to say she's innocent. And this is the only way she has of proving it. So, any comments, questions, thoughts?
Yeah.
Oh, yay!
What really bothers me, other than the crime itself, is that I don't personally feel that that justice is being served. And what I mean by that is my understanding, especially with a lot of people who have passed through the prison that she is in now, it is essentially like a cupcake camp.
Mm-hmm.
And that's very bothersome.
Yeah.
And how she does seem to revel in this attention, both before and after her conviction. When I say before, it's, the modeling agency wanting to work with her after the accident,
Mm-hmm.
and, like the Daily Mail UK, and of course, just the national attention and the way that her mom and her glee over that laugh, smile, like just showing so much, not because of we're going to get justice, but
yeah,
it shows no real remorse whatsoever.
And oh, go ahead, Lisa.
Go ahead, Kyle.
Well, say no, I agree. And I mean, I was contemplating, like, I think if you gave her the choice to do it again with the exact outcome, I think she would, because I think she is so infatuated. Like, she's fine, she's gotten the
Mm-hmm.
attention she wanted, and I think she'd do it again. And I mean, I still go back to, I mean, none of it was justified, but like, poor Davion. Like, I mean, the psycho could have at least not killed both of them. Like, I mean, I'm
Right.
like, bear with me, like, forgive me the clumsiness. Like, she has, I mean, it's not justified. She has a motive for Dominic. Poor Dane, he was just there. Like, could she not have just said, "Hey, please don't get in the car. Like, I have to talk to Dominic." Like, why did she have to include him
And
too?
I personally think I think that she was raging, and so she did not care if all of them died.
Yeah,
And second of all, I think that maybe part of the calculation was Davion being in the car gave her some plausible deniability.
yeah. Well, and
Whatever my relation, and that's what they say. I had no reason to
yeah.
hurt Davion. I had no reason to hurt Davion.
Well, and you've heard me say 1,000 times that a lot of times I feel like how the killers act after the crime and the conviction is really telling into like convinces me their
Hmm.
guilt. And to what Rick said, I mean, the way that she's behaved and just her parents behaved, I mean, there's like zero remorse. Like she at all does not act like anybody who lost the love of her life or who has any
Yeah,
remorse at all.
she's the victim. She's going to play the victim. And,
And
she's a victim of, she and her mother are constantly saying the Russos did this to her, that, they put the fix in. There's there's some big conspiracy against her,
Yeah, it's
and
crazy.
I was gonna say, when you look at her selfies, including the one that came out recently from the prison, it's the same exact look and the same exact pose. And the one that just came out from the prison, her face looks like she has rosacea.
Yeah. Well, it's
It's
just like
entirely too red.
that scene at the end of the crash where I guess she didn't realize there was a second camera and like they stopped the
Yeah.
main camera and I forget what she says, but you can just tell like this is all like a movie to
Mhm.
her.
Yeah. So, anyway, oh, and that hair in it's like somebody said, when did she become Rankisha? With the hair on top of
Yeah,
her head. And
yeah,
like kind of, it's like there was a comment on Facebook, and it was hilarious. It was like, that girl is from whiter than white Strongsville, Ohio. What the hell does she think she's doing trying to look like a sister?
yeah. Well, and back to Rick's point. I mean, this was cold-blooded murder. If she had done this with a gun, she'd have gotten life in
Yeah.
prison. So she's
Yeah.
really gotten lucky. I hope she never gets out, but the fact that she's eligible in what 15 years is tragic for cold-blooded murdering two people.
Well, her disciplinary history in prison is not gonna and it's
Yeah,
not
that's
gonna
what I
change,
think you're right.
because
Yeah,
you
it's
beat me to it.
the
I was
the
going to mention that.
the problem for her in school was she would curse teachers out right in the classroom
yeah.
when they told her to get off her phone. There's like one time she was on the phone in the classroom. The teacher said, "Put the phone down, Mackenzie." She said, "I'm playing a game with my mother." It's like
Well,
the
and I,
parking people, like thinking, "I'm only going to be there a minute, so it's okay for me to park in a handicap lane
yeah.
because I'm
Well, and I
playing a
get
game
the
with my
sense.
mother. You can't tell me anything."
I know she likes all the attention, but I've got to think too, right? This is just going to put, I mean, it already has. It's got to put a target on her back for the inmates too, right?
You would think, but from everything that I understand is that it is basically a cupcake camp, and she's kind of queen bee in there, from my understanding.
Mm,
And she has some social media posts and some text and some things that she's done and said. She said she was dropping the N word about another student in, I think, an Instagram post, um, or a Snapchat. And I think that she is a bully. And so anybody who threatens her, she's going to take them down. And she and one of her friends had a burn book about all the horrible things they'd done to people and horrible things they were going to do to other people. So, I mean,
yeah,
she is not a nice person. She's not a sweet, innocent little girl, although that's what she tried to look like at trial.
right.
Um, but and then her family gives, every time you see like an interview or something, her family gives these pictures of her like when she was like 14 with no makeup, where she looks like a little girl.
Right.
And then some of her supporters are calling Dom a pedophile and shit like that. It's like, he no, he's like 2.5 years older, or 2 years and 10 months older
Yeah,
than she is.
Yeah, like about 3 years, give or take. Yeah.
And so
right,
he's not that much older than she is. And
right,
they started going out when she was 14, he was 16. There's
And
nothing wrong with that.
and the parents allowed her at
Exactly.
17 to
Exactly.
sleep at his house and then him to even be there.
Yeah.
So, if people are saying that, then you must say something about her parents who allowed it as well. If that's how strongly
Oh,
they wanted, they want that
no.
conviction, then why
right.
don't you blame the
In
parents for allowing that?
in spite of this in spite of the evidence from the Snapchats and the texts, they are trying to blame everything Mackenzie ever did on Dominic, that he forced her to do those things.
Yeah, the parents are a piece of
And
work.
it's like, y'all are disgust. They ought to be in prison with her
Yeah,
because they
they ought to
were
have their
certainly
other kids taken away from them.
accomplices. Well, their daughter is now an adult, and she, like I said, Danielle, the younger sister, is an adult. She appears to be in college in North Carolina. Um, she's not like Mackenzie at all. And from what I understand from some of the comments the Russos made, Mackenzie was the favorite child, and she was not. But she has overcome that, and hopefully has distanced herself from her family and her sister.
Yeah,
Although her mother tries to make it sound like she totally supports Mackenzie. And maybe she does. I don't know. But all right, so let's go through. I do have, as I promised, I do have some media and miscellaneous things to say before we sign off. There are some documentaries and true crime series, TV, whatever, about the case. First off, we have Killer Cases. It was released on December 25th, 2023. It's available on A&E or through Hulu. Called Murder on Wheels, season 4, episode 12. Pretty good. We have Mean Girl Murders, which was Max Hulu. You can find it on Max or you can find it on Hulu. Its episode is titled Under the Influence, and it is season 2, episode 7. As much as I hate him, Vinnie Politan Investigates, January 22nd, 2025, was released, our first air date. This is on Court TV, the case against Mackenzie Shirilla, and it was pretty good. I watched it. I despise Vinnie Politan, but I suspended my dislike for this episode, and it was pretty good. And these are for some deeper dives into some of the cases and some of the aspects of the background stories. Then, of course, there's The Crash on Netflix, released May 15th, 2026, uh, about the 2022 high speed car crash in Strongsville, Ohio, involving Mackenzie Shirilla. That's where you can see her looking at an attorney say, okay, well, I didn't want to sound too bad, but how did I do? Or did I cover all the points or something like that? Um, Showing that she feels no true remorse, that she's just speaking the words because she thinks it makes her look better.
Hmm.
Because
yeah,
she does
exactly.
care. She and her mother especially care about what other people think about her as much as they say they don't.
Yeah, absolutely.
Because they're always trying to influence opinions about her. Again, go watch the sentencing.
Yeah,
Natalie Shirilla, her statement in the sentencing, it is just really disgusting. And I'll bet you anything it might have been the thing that turned that judge to add life onto the sentences.
yeah, exactly.
And then finally, there is a podcast, a Netflix podcast. I haven't listened to it, so I'm not saying it's recommended. Called Allegedly. It was released on May 20th, 2026, and it's called Hell on Wheels: the Case of Mackenzie Shirilla. I may watch that tonight if I feel like it. Now, there are some podcasts I do want to recommend because I've listened to them kind of to get a feel for the case and some of the background. And really, I can't do justice to those issues, but these podcasts do. Moms for Justice, she provides a deep dive, or they provide a deep dive into the police files, witness interviews, text messages, and jail calls between Shirilla and her mother, Natalie. They also provide counterpoints to some of the interviews by Natalie and Steve Shirilla. The Big Sister Unhinged, it's hosted by Dom's sister, Christine Russo, and a cousin named Becky. It provides an insight into the relationship between Dom and Shirilla and refutes many of the claims made by Shirilla and her parents in various media interviews about the relationship and the facts of the case.
Hmm.
They also provide a heartbreaking insight into the impact of society's obsession with true crime on the family members of the victims who have been left behind. And then finally, Rotten Mango. She provides another deep dive into text calls, behind the scene relationships, and pre crash events in the lives of Shirilla, Dom, Davion, and their friends. These podcasts have also interviewed people. I believe Mom's interviewed a producer of one of the true crime shows. Uh, Divine Flanagan was on Mom's, the Big Sister Unhinged, rather. Rotten Mango has interviewed Rosie and a couple of other players in the drama. So those are three podcasts I would recommend, and they have a plethora of episodes about this case. So those are ones I've listened to. There are many, many, many more, but I haven't listened to those, and I can't really recommend whether they are, um, what they are or what they do. So, but that's it. We done.
Yeah. I'd also like to note, just to cap it off, that a prison name that Mackenzie embraces is Shrilla the Killer.
Yeah. Yeah.
Wow. Well, I just, as a quick side note, and pardon me that it sounds a little hypocritical, but that comment of, I think, the Russo parents, of how, like, for so many, like, true crime is such a entertainment for so many people. And
Mhm.
I don't know, I think it hits me that there's actually, like, true crime conventions, which to me is like, I don't know, probably just me being a hypocrite, but it's
No,
like,
I
okay, this is
agree.
kind of weird. Like, it's one thing you're kind of watching the cat, but actually, like, so into this that you're going to a convention, it seems a little bit.
Yeah.
No, I agree with that 100%. And I think there's a difference between having an informative podcast covering cases in an ethical, factual way versus putting stuff out there to get views and clicks and then having these true crime cons, or, I mean, some of them are even cruises.
Yeah.
And,
Yeah,
and you have these people, they go to there, they want these autographs and they become like stars. And it's like you're missing what this should be.
Mhm.
And
right,
yeah, the con situation, no, I agree with you. Now, sometimes there can be some good things there, like when parents are there to advocate for their loved ones. That's one thing, like parents with kids,
Yeah.
or what have you. But a lot of it is just a bunch of like drooling nonsense of people just loving the attention of the consumer.
Yeah. And
yeah, absolutely,
a lot of it is also infected by the current inability to agree to disagree. So, if you're on one side of a case and you believe somebody is guilty and five other podcasters believe that they're not, they're going to come after you and attack you and try to silence you.
right,
And so if you go to one of these things, you're going to become a target of those other people at these things.
right.
Um, Especially if you tend to believe people are guilty rather than, believing I mean, they're trying to claim a Brady violation because the prosecution didn't enter evidence of pots. Her father has alleged that
Yeah, that's
It's
crazy.
ridiculous.
because the investigators, quote, knew she had POTS. Well, yeah, they knew that was a diagnosis, but they also talked to the doctors who treated her, and the doctors who treated her said, I don't see any evidence that that this accident was caused by a medical condition. So, all
Sadly.
right. So they're just delusional.
Yep.
Cuckoo.
Very much so.
All righty. Well, thank you again, Rick, for joining us.
My pleasure.
Yeah, take
We'll
care.
have
Good to
to
see you as always.
Likewise.
remember you
Thank you.
whenever you have a case from Ohio.
Thank you.
All right, and thank you again, Kyle, because I know you were traveling a little bit today.
Yeah, absolutely. Thank you
So,
for all your work.
and a little bit of a program note: I am going to extend the length of time between episodes from 2 weeks to 3 weeks, because that tends to be when things fall. Anyway, I'll say 2 weeks, and then most of the time I'm not ready in 2 weeks. So we're just going to go ahead and say 3 weeks officially now, and I think that'll be a little bit more of a realistic target, at least for me. So that's about it. We're Any other final thoughts on Shirilla and her cuckoo parents?
I hope she actually ends up getting POTS and she falls, trips, and busts her head.
Yeah, that would be nice. Well, I hope that I hope somebody bigger and badder than her comes into that facility and starts to give her a taste of her own medicine.
I
Yeah, I
think
just feel like at some point, I think at some point her mouth is just gonna write a check that her body can't cash. It
Yeah, yeah,
may not be today, but at some point
yeah.
she's just gonna push it. I think it's inevitable.
So, but perhaps someone taking offense to her trying to act like she's a sister. So when she's a little white girl from Strongsville, Ohio.
Yeah, exactly.
All right. Thank you for listening to Based in Fact, a true crime podcast with Lisa O'Brien, Kyle Evans, and our guest host, Rick Mullinax. If you like the show and want to know more, you can subscribe to our YouTube channel, find us on Facebook, or follow me on Twitter at O'BrienLN. Kyle and I will return in 3 weeks for episode 11, State of Tennessee versus Krista Gale Pike, part 1. In 1995, Pike, Shadola Peterson, and Tadaro Ship lured Colleen Schemmer to an abandoned steam plant near the University of Tennessee campus, where they attacked her, beat, tortured, and murdered her. Pike was convicted and sentenced to death in 1996. We'll talk about the crime, the arrest of Pike and her accomplices, her trial and direct appeal, and the years of post conviction claims that she's dropped and picked up. Until then, have a great 3 weeks and stay safe.